Can a husband refuse maintenance just because the wife is educated? Let's understand what the Honorable Supreme Court has said. Hello everyone, welcome to NRI Legal World. I am Advocate Avantika Raita. Today, I will going to discuss a very important and recent judgment delivered by Honorable Supreme Court of India. This judgment is extremely significant for matrimonial disputes, especially for NRIs who are involved in matrimonial litigations in India. In this case, the dispute was between the wife Anamika Jain and husband Dr. Atul Jain regarding the grant of maintenance. The wife approached the court seeking financial support, whereas husband opposed the claim by arguing that wife was well educated and capable of earning money and therefore not entitled to maintenance. Initially, family court granted maintenance of rupees 15,000 per month. However, the wife found this amount insufficient and approached higher court seeking enhancement. The key issue before the Supreme Court was very crucial: whether a spouse who is educated and capable of earning money can be denied maintenance, and how should court assess financial independency in today's modern society. The Honorable Supreme Court has made some very important observations in this case. Firstly, the court clearly held that qualification is not equal to income. Just because a person is educated and capable of earning money, it doesn't mean that they are actually earning. Secondly, the court emphasized that the maintenance is not just about survival, it is about ensuring a dignified life. For this, the court relied on the earlier judgment in Bhuvan Mohan Singh versus Meena, where it was said that the wife should not be forced to live like a destitute or depend on others for basic survival. The court further stated that a wife is entitled to live a life similar to the one she enjoyed in her matrimonial home. Another important observation was that the court must consider the actual financial status, including real income, assets, and financial dependency, not assumption about earning capacity. The Supreme Court also took into the account modern realities like inflation, rising expenses, and changing lifestyle while deciding maintenance. Now coming to the final decision of the court, the Supreme Court enhanced the maintenance from 15,000 to 30,000 per month. The husband was directed to pay this amount by the 5th of every month starting from February 2026. Additionally, the court ordered payment of arrears amounting to 8,10,000 for the period from July 2021 to January 2026. This amount can be paid either as a lump sum or installment within the period of 4 years. If paid in installment, at least 1/3 of the amount paid through quarterly installments. This judgment is important especially for NRIs. Many times in NRIs matrimonial disputes, one party argues that the other spouse is qualified or capable of working and therefore should not be given maintenance. However, this judgment makes it very clear that earning capacity alone is not sufficient. Indian courts will look at the actual income and financial reality, even if one of the party is residing abroad. So NRIs must understand that they cannot avoid their legal responsibility of maintenance on such grounds. To conclude, this judgment reinforces a very important principle: maintenance is not a charity, it is a legal right. And the Supreme Court has made it clear that dignity, financial stability, and realistic assessment of income are the key factors of deciding maintenance. If you are dealing with matrimonial disputes, so you can follow up with this judgment so that you can aware with your legal rights. If you found this video useful, don't forget to like, share, and subscribe NRI Legal World. Thank you.